this is why we did it and this is okay and all that. It's just an inadvertent mistake. Now, there obviously are a lot of legal questions to be addressed, but again, those are questions for the court, and not the basis for a factual hearing. You don't have anything. You have one sentence to say. It was inadvertent mistake.
Well, I mean, Mr. Chief Justice, I think in a case where the president's going to say that it's an inadvertent mistake is enough, and the potentially removed official is going to come in and say it was an inadvertent mistake, then you're right. I think the hearing's not going to matter that much. Now, in the real world where you have no precedent for this kind of removal, I think if there were notice and opportunity for a hearing, there might be an opportunity to not just present the factual evidence, but to also make the case. And given these particular facts about this particular inadvertent mistake, that isn't a basis for removal.
Well, I think you're talking about the legal arguments, though. The arguments we're hearing today.
I think that's right, Mr. Chief Justice, and I do think those could be made in a preliminary way in the process that was provided by the executive branch. But as I alluded to, I do think on the substantive question of what's for cause, there needs to be judicial review. And I think there needs to be judicial review of that question for all the reasons that were alluded to in the various colloquies. Because if there's no judicial review, then this is all kind of a joke. I mean, we can sit here and posit that, well, this would be for cause and that would be for cause, but none of it would matter because there'd be no judicial review.
Well, on the question of what is for cause, what the district court held was that it must relate solely to in-office conduct. And you defend that with one caveat that if the office holder is indicted later while in office for pre-office conduct, then that might be cause for removal because a person under indictment wouldn't be able to devote full attention to the job. But other than that, you defend the district court's holding. Is that correct?
We do defend the district court's holding on that, and I would understand that is the rule for all the statutes that have INM.
There's nothing under a for-cause removal standard. There is no pre-office conduct that could constitute cause.
That is my frontline response. I happen to have a backup argument, which is if you pick up the common law, then you would pick up.
Well, let's take your front line argument first and see how far you're willing to go. Suppose that the office holder was permitted to resign from a previous job under a non-disclosure agreement based on long and egregious pattern of sexual misconduct. That would not be for cause. That would not be cause for removal.
So what I would say, Justice Alito, is I don't think that would be INM. And so if I'm going to stick to my frontline position, then that would not be for cause. It would certainly be a basis for impeachment. And I think in understanding why we've had INM for at least 90 years.
All right, I understand your position. How about if after the person assumes office, videos are disclosed in which the office holder is expressing deep admiration for Hitler or for the Klan?
I can only imagine where these typos are going to eventually go, Your Honor.
Well, yeah, because your position.
I'm going to stick with my position.
Well,
of course I'm going to stick with my position. And I'm going to say that's an official that would be impeached in a heartbeat, and the fact that they would be impeached in a heartbeat is going to cause them to resign in half a heartbeat. And this has not proven a problem. I mean, for better or for worse, whatever you think of Humphrey's executor, we've had 90 years
Mr. Clement, what's your backup argument?
My backup argument is the common law standard. Justice Sotomayor alluded to it, which would be that there's a removal basis for an infamous crime of the kind that is disabling for public office, and and at common law it also required a conviction. So it's an exception. It helps me with a couple of these hypotheticals.
No, it doesn't help you.
It's not going to help me with the Justice Alito.
It doesn't help you.
There's no conviction for the Hitler video.
You have a backup to the backup.
Impeachment. It's the ultimate backup here. This is not a situation where you're being asked, have to tie yourself to the
argued in the past that impeachment doesn't cover private conduct. You obviously disagree with that, then.
Well, I certainly see, but this actually kind of makes the point about judicial review, right? I mean,
I'm not saying I agree with that, by the way. It's just been argued.
Right, but what I absolutely agree with is the Walter Nixon case says that there's no judicial review of the impeachment determination in the end. So whatever the House and the Senate ultimately determine I mean, they can make constitutional law too, and they can determine whether private conduct is or is not out. And if they say, and with these hypos, I mean, and we can go down the road of the hypos and they'll get worse. I am
The
confident.
backup, to use Justice Gorsuch's term, would be the infamous, but you don't need a conviction.
Right. No, absolutely. And of
And
course.
that seems to answer a lot of the difficult typos, correct?
Correct, but the reason I want to spend at least a moment answering some of the hard hypos is not because I'm a masochist. It's just because those are got to be the answers under I&M.
Your answer is that those are funneled to the impeachment process.
That's right, and that's the
So
way
why-
I&M has worked for 150 years, and I think it would continue to work. It hasn't proven a problem in practice, but I'm not resisting very hard the backup to the backup on that because I don't think we're close. And of course, look, all of these are hard questions, which is all of the reasons why it's kind of crazy to decide this on an emergency application.
Yes, well, there are a million hard questions in this case, and it is an emergency application, and very difficult questions, either no precedent or very conflicting or very uncertain body of precedent. But there are two things were decided by the lower courts. One, that what I just explored, the district court said it's got to be in-office conduct, nothing that happened before person took office counts. And then the D.C. Circuit said that your client had a property interest in her office, and therefore a due process right. Is that right? She had a property interest in being a governor on the Federal Reserve Board?
So I think there's a perfectly reasonable argument for that, but I also think that there's a better argument that's a constitutional avoidance argument. And what the D.C. Circuit did in a per curiam opinion is sort of an example of what happens when you're trying to rush all of this, which is you jump right to a constitutional holding when there may be a perfectly good constitutional avoidance statutory holding there. And I think we've now had a couple of months and a bunch of amicus briefs to ventilate some of these things. And I think you get, with that ventilation, you get an understanding that there is a very good statutory argument. And I do want to talk about best reading a shirt left.
Why wouldn't that be a basis for sending it back to consider these arguments in the first instance? If you aren't prepared to defend the due process argument and perhaps your frontline argument on that things that happen before employment are categorically and always off the table. If those two decisions, which, to be fair, were of course issued under a time constraint, might have some flaws, why shouldn't it go back to reconsider it? You've advanced a lot of new arguments here. So have your friends on the other side.
So it should go back. It should just not go back with an emergency stay being granted, which is an extraordinary relief that depends on my friends on the other side showing an extraordinary burden of irreparable harm and showing that they have a likelihood of success on the merits. And I think likelihood of success on the merits in this context doesn't mean just a likelihood of showing that the two grounds that were seized on in the quick briefing below are wrong, but that they're actually right. And I think the briefing here has done two things. I think it showed that we're right. I'm not abandoning my frontline arguments, but I love my backup arguments. I think they are very strong. And I think it shows the sort of, the problems that happen when you try to decide some of the most important issues of constitutional law in this kind of rushed way.
Can I ask you about the mandamus question? Why isn't mandamus the appropriate avenue here?
It is an appropriate avenue at the end of the case. Even at the end of the case, though, I think, and this is consistent with what Professor Bray says in his article, even at the end of the case, I don't think you have to leap to mandamus. I think you can have a declaratory judgment
Well,
first.
let's put the declaratory judgment issue aside, because we can talk about mandamus for a second. Assuming there is such thing as a preliminary injunctive relief for mandamus, which I'm going to ask you if that's a thing, first of all. And second, if it were, wouldn't the standard that you'd have to show likelihood of success be the likelihood of success under the mandamus standard?
So a couple of things. I mean, I don't like hearing preliminary mandamus any more than Judge Friendly did.
No.
I don't think it's the right way to think about it. I think it's preliminary relief to preserve the status quo, or if you want to be more specific, preliminary relief to preserve a de facto officer in their office while the case proceeds. And that is a relief.
Why isn't that preliminary injunction or mandamus? I know what those two buckets are. I'm not sure I'm familiar with the third one you're describing.
What I'm describing is a preliminary injunction. I'm just saying it's
so
not
it
a
is-
preliminary mandamus. It's a
Wouldn't it have to be, though, if your cause of action were mandamus, and let's just suppose that's what it is, it would be preliminary injunctive relief because you have the likelihood of succeeding under the mandamus standard, I would have thought.
Well, perhaps. I mean, two things about that. One is, I'm not sure in this kind of mandamus posture, I don't think I agree with General Sauer that the standard is the standard you would have in like a Cheney situation. I do think this kind of original mandamus as the remedy in this particular situation, I would resist the idea that that's sort of the standard, more appellate mandamus standard. That's a debate, even with all the briefing we've had, we haven't had a good chance to really duke it out on that. But I would say that's part of the reason I resisted the idea that you have to go to mandamus, because I do think you would have declaratory judgment. I do think declaratory judgment.
I asked you to put that aside for the moment.
No, and I tried to, as long as I could.
All right.
But
Then I give up. Okay.
Then to answer your question, I really had to get to declaratory judgment. I would like to say this is an issue the D.C. Circuit has thought a lot about. And there's a particular case worth reading, the Swan against Clinton case. And that's a case where they kind of wrestled with this question about would you have mandamus against the president at the end of the day? Can you direct the president? And there's a great concurring opinion by Judge Silberman where he basically says, look, the judiciary is creative and clever enough to figure out a way to fashion injunctive relief against the lower federal officials. And that solves the problem about having the relief run against the president. And the reason that the D.C. Circuit has wrestled with that in a couple of contexts, and I think the Chief Justice alluded to this, if they were really right about that, then you'd have to wrestle with this at the beginning of the case as to whether there's any redressability at the end of the case. And in the Swan case and even in the Severino case, the D.C. Circuit has said there's not a redressability problem. We can figure out a way to direct the relief at the lower government officials, and that will be sufficient under the day.
And that happens at the end of the case, right? After the whole thing has been litigated and some court, perhaps even this court, decides the removability question. The president does not, we would say, have the right to remove her. And then we go to remedy, and the question is there a mandamus or not? The reason why I thought mandamus wasn't on the table right now is because we're not there. We're in the middle of the case. No one has made a definitive determination about the president's right to remove her. The question now is just in the interim, while that issue is being litigated, what happens? And that's about the equities. That's about whether it's going to be more harmful to leave her in the position than not. That's what I thought this motion was about.
I mean, I think that's right, but it's specifically about whether you can get some sort of preliminary injunctive relief to preserve the status quo and keep the de facto officer in place. And I do take Justice Gorsuch's question, which is at the end of the rainbow, all there is mandamus, and you can't have mandamus against the president, then at this point you'd say, what's your likelihood of success at the merits? And you would say, there's no likelihood of success in the merits. But I think, as I alluded to, even before that, you'd say, is there any redressability here?
But wait, I'm sorry, why would that be a merits issue? You'd have no likelihood of success on the merits, you just have no remedy. You would win on the merits. The merits are that the president wasn't supposed to remove you. But you would lose because there's nothing to lose ultimately in terms of not having a remedy, right?
Well, I mean, you could draw the distinction that way. I think if you have no remedy at the end, you probably have the redressability problem at the front end, which is why the D.C. Circuit has addressed this on a number of bases. These are not emergency application decisions. These are decisions of the D.C. Circuit. They obviously don't bind this court, but they are the considered judgment of a court that's dealt with, with all the removals there have been, and there haven't been a lot of them, but with respect to other officers. So, I think that's pretty good authority.
What would judicial review in this context look like? I mean, this is not a question about what the standard is. It's more a question about, is there a kind of deference to give to the president? How does that deference operate, whatever the standard is?
Sure. So I would divide between sort of factual questions and legal questions. As to the factual questions, I would say that there's going to be a degree of deference, and the degree of deference depends on the degree of process that's provided. So if the president wants to go full Taft, I don't think the courts are going to be in a position to second-guess the factual determinations. If the president wants to do something more informal, he's entitled to do that, but then I would think there'd be more of a scope for, having more hearing, more process in the judicial forum. On the question, the legal question, I would say in a post-Loper world, there's no deference to the legal questions, and the courts are going to have to decide ultimately what are the boundaries, the metes and bounds of for cause. And the only other thing I would add is I think that you're going to want to erect meaningful standards of cause because, there's kind of two options here. You could either have judicial review that spends a lot of time looking into pretext of the president, and that just doesn't seem like a good thing for the courts, for the president, or anybody. Or you could erect relatively demanding standards of cause, and that's going to, I think, obviate the need for that kind of pretext inquiry.
Yeah, so General Sauer's version of cause, which is it's not policy, it's something other than policy. Why isn't that the backup to the backup to the backup?
Well, because it would kind of destroy the whole point of having an independent central bank in the Fed. And it just seems to me like at some point, we're all here on the assumption for this case that the Fed is a uniquely structured institution with a distinct historical tradition. And so if that's true, and then you tick through the statute and you see all the things that Congress did, including, Congress wasn't just trying to take the Fed and keep it from sort of being unduly influenced by the president when it came to rates right before an election. It did the same thing to itself by limiting the power of the purse over this institution. And then you go through and, just every provision of the statute is trying to treat this unique institution differently. And then at the end you have for cause, which, could mean what General Sauer says, but if it means what General Sauer says, then the whole enterprise was a lot of trouble for nothing.
On the future judicial review and what that looks like, would the witnesses testify in court, or is it done on the record established by the executive branch, or does that maybe depend?
I would say it depends on what kind of process was provided by the executive. And look, I agree with General Sauer. This court's not going to dictate, here's Robert's rules, have at it. But I think this court can do something useful, which is essentially to create an incentive for the executive to provide something that's a little bit more protective, a little bit closer to Taft than something incredibly informal.
That sliding scale is extraordinarily unhelpful. What is the minimum that the executive, in your view, has to provide? The minimum type of hearing that you think is required by this statute?
So the minimum hearing, I think, would have three components. One is notice, and that's really not much of an issue here. I agree with that. The second is an opportunity to provide evidence to the decision maker, and we don't think that happened here. And then the third thing is some effort to keep the final decision maker from prejudging the issue. And part of the problem you have in this particular case is that I think the president was proceeding on the understanding of the statute that's faithfully represented here by the Solicitor General, which is he wasn't acting like a removing authority that was subject to any due process. Because if he were sort of subject to that, he wouldn't have said in his opening tweet, "You must resign," and he wouldn't have said 2 days later, "Resign or be fired."
So does that mean it has to be a body of disinterested decision makers?
No.
People who are not part of the executive branch and can exercise independent judgment that way? No? Then
No.
what does it require?
It requires just what I said: notice, an opportunity to provide evidence, and a decision maker who hasn't prejudged the issue. That decision maker can be the president. I'm not sure I necessarily recommend it as my choice A, but
how can it not be the president? The statute authorizes the president to make the removal decision. How could it be anybody else?
Well, look, if you believe in the unitary executive theory, then anybody that makes the removal decision is acting on the president's power. I think it would work. I think the way it worked for Taft is the tribunal made a recommendation and then Taft executed.
Right.
So it was the president making the decision.
The president has to make the decision, right? Or delegate it to somebody who he wishes to make that decision,
Yes.
who's reportable to him.
Yes.
Okay.
At will.
At will. Yeah.
Right. Absolutely.
Okay.
And the president can be the final decision maker, but if he's going to be the final decision maker and there's a due process right, and I mean that statutory or constitutional, then, he needs to be a little bit careful and say, these are the allegations. He can't start by prejudging the issue by saying, resign.
Mr. Clement, your understanding of for cause? You know, you went through hypotheticals with Justice Alito about how it doesn't cover pre-office conduct. What about conduct in office that doesn't relate to the discharge of the office? Like, what if you take some of Justice Alito's examples, but it's like Nazi videos while the governor is in office, or you know, things that would be misdemeanors rather than infamous crimes like shoplifting, you know, stealing things, domestic abuse. Would those things be cause for firing, or they don't really seem like impeachable offenses necessarily?
So I don't think those would be removable offenses under INM.
Okay.
And so I don't think they would be removable offenses under for cause properly construed.
So there's nothing that the president can do to get rid of someone who does those kinds of things while in office?
So, I mean, you know, some of the things we're talking about, you know, seem like better grounds for like an intervention than for removal.
Well, I mean, I could come up with others, but
I mean, absolutely, absolutely.
But sorry, keep going.
You know, I'm going to fall back on my answer, which is that's my understanding, and I think it's actually everybody's understanding of how INM works.
But it doesn't say INM. And so, I mean, I appreciate your argument that INM and for cause are one and the same, but you also kind of pull in your fallback some sort of like gerrymandered things like infamous crimes, but you don't have to have a conviction. I mean, so it doesn't say INM.
So a couple of things. One is, you know, I'd resist, I mean, you know, gerrymandering is generally not a compliment. So I would sort of say that what we do is we bring in the common law. And that's what we do. And I really didn't try to gerrymander it beyond that. But let me make the argument, which I really...
Can I just ask one clarifying question? I thought the common law, though, required conviction.
It did. And that would be our sort of frontline backup position, if you will. I mean, but the happy thing for me, I think, is at this stage of the case, we win under all these variations, and ultimately, you know, some court, and it may be this court, is going to ultimately say these are the metes and bounds of for cause. Now, I think I have some pretty good arguments that it really is just INM plus ineligibility as kind of informed by Section 244. And let me just give you, like, my best shot at it, which is this is the very unusual situation where, you know, we know that Congress was literally waiting for this court's Humphreys executor decision. And then it gets Humphreys executor's decision, and this court in Humphreys executor at least 3 times uses for cause and INM interchangeably. And then the senators themselves in the debate, now you got to look at debate, but I think even Justice Scalia looks at debates for original public meaning. The senators in the debate use the terms absolutely interchangeably. And so you have 2 of the 3 branches of government, original public meaning, saying for cause, different words, but what it means is INM. But I do think it must, you know, you got to make sense of Section 244 of the statute, which does provide a very specific eligibility requirement. And as I said before, I think if some Fed governor was insisting that they also wanted to be a director at Chase National, they could be removed for cause for that.
Okay.
Do you think that there's a way at this posture of dealing with this case so that we don't have to confront the question of exactly what the for cause standard means?
Is there a way to deal with it at this stage without having to ultimately say that? I mean, sure, there'd be a lot of different ways to do that. You could say that for cause, I mean, you know, one way to come at it would be to say, at a minimum, for cause doesn't mean apparent misconduct or gross negligence. And I think that would be sufficient to decide the case, at least at this juncture. And I think you could say something more. I mean, you know, obviously, if you took my position and said it means INM plus ineligibility is informed by Section 244, I think we'd be done here, because I don't think there's an argument, at least that I've heard at this juncture, that the conduct that's at issue here is either INM or ineligibility.
Couldn't we also resolve it by not even going to the likelihood of success on the merits element? I mean, you have the president would have to have all of them to get a stay, and we could do it on harm, right?
Sure. I mean, you know, look, it's an emergency application. You could deny it without opinion. I mean, that would be a little strange at this juncture. But you know, it is an extraordinary application made on a preliminary record. And so, you know, you sort of have a lot of optionality at this point. But I will say this. I mean, you know, I do think the briefing in this in this court, which was, sort of unusual. You had the application briefing, then you had amici, then you had this supplemental briefing. I think it's been incredibly helpful in excavating some of these difficult questions. I've looked at almost all of these common law cases. I have a different view than General Souter on some of these questions. In particular, I think it's very important, and I want to get this out, that if you look at Shurtleff, one of the things at Shurtleff, there's a line there that says that where Justice Peckham is invoking the common law, and he says that as long as there's certain causes, statutory restriction for certain causes, that's the term he uses, then there's notice in a hearing. He cites 7 common law cases. Now, if you look at those common law cases, 3 of the 7 just say for cause. And 2 of them say good behavior, which is even less. And then 2 of them have a more specific cause. So that's, to me, the best contemporaneous evidence that we're actually right about the issue, that if it just says for cause and it doesn't say for a particular kind of cause, you get notice and an opportunity for hearing. But that's the kind of thing you can excavate on full briefing on the merits that I don't think you can in an application.
Thank you, counsel. I guess I get back to where I kind of started, and all this description, these are all sorts of legal issues. You don't have anything more to say on the facts, right? It was an inadvertent mistake. I don't see how you can say anything more. We've had a broad range of discussion on the legal issues. Now, it's very helpful for us to have lower court decisions on those, and maybe that's reason enough. But again, I guess I don't quite understand what sending it back would be for, other than airing of the same sort of issues that we've been airing this morning.
Well, I'm not going to resist too hard you deciding this on a more substantive ground that gives my client sort of, relief that's more enduring at this stage. But I will say that, another one of these great common law cases is the Street Commissioners of Hagerstown, which happens to be the case that Black's Law uses for its definition of cause. And one of the things it specifically says there is, even if you don't think the due process, the notice in a hearing is going to amount to much, it's still an error not to give it, and we're still going to essentially not allow this removal to happen because there wasn't notice and an opportunity for a hearing.
So it may not be an error to go through the process of your client coming in and say it was an inadvertent mistake. Since it was inadvertent, I don't have much more to add to that. And the argument on the other side being what the President said, well, I think this is a serious enough mistake, and so that's why I'm removing her.
There's only so much I can say to resist the idea that, we think this was at most an inadvertent mistake. We would have liked a more, a sort of opportunity to do that and present our actual evidence, which would have substantiated that. But we also think at the end of the day, inadvertent mistake isn't very close to for cause, particularly when you understand the unique nature of this institution.
What is your actual evidence that would substantiate the fact that it was an inadvertent mistake?
I think the fact that there's an attachment to one of the applications that describes it as a vacation home.
Well,
and that's not.
We've got that too.
I understand, but the President didn't. And it seems to me that usually when there's a procedural omission, one doesn't say, well, at this point we got everything we need, so forget the procedural omission. Again, I'm not really going to resist that, especially if you're going to, say you're with me on the substance. But it does seem to me if you want to reserve judgment on the substance or you want more briefing on the substance, you could say, and this is, whether it was constitutional due process or statutory due process, I think this is the gist of the D.C. Circuit's decision, is at a minimum, you didn't get the process you were supposed to, so the government doesn't get this extraordinary emergency stay.
Justice Thomas?
Just so I'm clear, for you to prevail, we would have to say cause is the equivalent of INM.
No, I don't think so, Justice Thomas. I think you could really take any definition of cause that we've been sort of batting about, with the exception of General Sauer's definition, and we would prevail. I think the only, and I do think the definition that's presented to you by the President is a pretty extraordinary one, because, General Sauer's a very careful lawyer. So in his briefs, he doesn't talk about mortgage fraud, he talks about apparent mortgage fraud. And when you're talking about apparent misconduct as opposed to actually found misconduct, that A, doesn't get for cause, and B, it sort of is advertisement that you have a process failure. And so the fallback then is or gross negligence. So one way to think about this is if the standard of for cause is more demanding than gross negligence, then we certainly win. And we didn't even get a chance to sort of argue about gross negligence.
What is your, if it's not the equivalent of INM, what are some of the other standards that you would apply that would be sufficient for you to prevail?
So I think the single best reading of the statute is INM plus ineligibility as informed by Section 244 of the statute. I think then my fallback would be then you pick up the common law, and if the common law makes you uncomfortable because of Justice Alito's hypos, you could tweak the common law. But you would then be tweaking the common law. And that's why, honestly, at the end of the day, although it's uncomfortable for a few moments to answer some of those hypos, you always have impeachment as the backstop. And we had, 90 years, plus if you go back to the Interstate Commerce Commission of 1887, almost 150 years with INM, and this didn't really pose a problem in practice.
Justice Alito?
Do you think that we should decide this case on the factual ground that what is shown by the materials that are before us shows nothing more than gross negligence, which is insufficient? Should we make that factual finding in the first instance? I understood your answer to be, you should do that if you're going to find in favor of me, but you shouldn't do it if you're going to find the other way.
I'll stand by that answer.
Really? That's your answer?
That's my answer. I think it would be a little irregular, but this whole case is irregular. And if that seems to be the path of least resistance to decide this case in a way that is going to essentially obviate the need for this court to decide it again in a couple of years, that seems like a perfectly reasonable way to decide the case.
Thank you.
Justice Sotomayor?
This whole case is irregular. Starting with the Truth Social notice, or thinking of it as notice at all, certainly didn't invite an opportunity to be heard. But that's where we are. Now the question becomes, and you answered the Chief and said, I don't have more to present. I don't know where you presented anything. You have a letter from you that basically says that the application included notice that this was a vacation home. But that's never been given to the president. That's never been filed with a court, or no one's ever seen it. It's just statements being made. So I don't know why a factual hearing would be irrelevant. So assume, as I do for the purposes, that she did fully disclose this was a vacation home. So now the question is this what she did negligence or gross negligence? Does cause include just mere negligence? I think that you have a very strong argument under any reading of cause that mere negligence pre-office would not qualify, correct?
Correct.
All right. Because it would seem extreme to think that something separated from the functioning of the office, unrelated to the work of the office at the time it's done, that mere negligence would be enough. But the president called it gross negligence. Who decides that issue? Meaning, who decides whether something should be called negligence or just gross negligence?
So I would think that ultimately that's a mixed question of law and fact that would be ultimately decided by the court on judicial review, assuming you're with me that there's judicial review. I do think there would be an logically anterior, purely legal question of whether gross negligence is sufficient for cause. And just as I think I have a pretty good argument that negligence pre-office is not a sufficient basis for cause, I think I have a pretty good argument that gross negligence pre-office is not a sufficient basis for cause. And, in some respects, I think in the long run, it will be better to make clear that in the context of this unique institution with this distinct history, that for cause is several steps north of gross negligence even, because that's going to make it really something that the courts aren't going to have to get dragged into on a routine basis, where I think the lower the standard is, the more likely you are to have removals in the future, and the lower the standard, I think the greater is going to be the judicial temptation to think about pretext. And I'm not going to say that there's no role for a pretext inquiry, but it's not a happy sort of scenario for the courts to be considering pretext in the context of presidential decision-making. And it seems to me the way to solve that is to say there are real procedural and substantive kind of bite to this term, sort of for cause. You do have to do some kind of notice and opportunity for a hearing. I mean, even if it's an hour in the Oval, that's a big imposition on the president's time, and that's going to keep some presidents from removing somebody. And if they know that it's going to be judicially reviewed, then that's going to deter most presidents most of the time. And so I think kind of, it's like, what is it? High walls make for good neighbors. I mean, I think this is a situation where you do want to have those kind of meaningful legal requirements.
Justice Kagan?
What do you understand the government to mean by gross negligence?
I don't really know. I don't think they've offered sort of a theory of gross negligence, and that's why I don't think
You think it's just a label that they've put on this particular set of facts?
Sure, and if heaven forfend we end up with a whole common law of Fed governor removal, then we might eventually be able to sort of piece it together. But it seems to me that you could label an awful lot of things gross negligence, and that seems to be inconsistent with not just the for cause provision, but the whole structure of the statute. And I mean, Justice Kavanaugh alluded to the Morrison dissent and, Justice Scalia creating this beautiful picture of some independent counsel with nothing to do but to find a crime on somebody. But if all the independent counsel has to do is find gross negligence, then I don't think the independent counsel would need more than a couple of hours with most of us. I mean, that's such an elastic standard. And I just can't imagine that's consistent with all the trouble Congress went to make this unique entity insulated from kind of the political pressures of the day.
Thank you.
Justice Gorsuch? Justice Kavanaugh?
A couple things, just to talk again about the standard. I mean, getting the definition of for cause right, which we may not have to do in this posture, so I take that, is critical, because on the one hand, you have the independence of the Federal Reserve, which we've talked about. The other hand, we have people have committed, again, not talking about the facts of this case, but serious ethical or other wrongdoing, digging in and remaining in office. And it seems like your two answers to that, when you said your frontline positions, I&M, were intervention/resignation. And I'm not sure that really works with some people who are going to just dig in. They're not going to leave. And then the other was impeachment, but of course, with the 2/3 requirement in the Senate and the time constraints of the House and Senate, I'm not sure that's available as often as you say. All of which is getting me to the point of, I don't see how the frontline position really can be the final position without making kind of tilting the balance here too far the other direction from where the Solicitor General is. You just want to tackle that at all? I mean, you've covered it, but I want to get it out one more time so you can succinctly answer it.
Sure. I think the best thing that I haven't said already that I could add is I think in the unique context of this particular agency, you want to strike the balance more in favor of keeping an official who maybe in a perfect world would be removed, because this is the opposite of the situation in essentially all of the other situations, with the possible exception of like the tax court and the court of claims and the court of military appeals. Here, I think it's less important that the president have full faith in every single governor, and it's more important that the markets and the public have faith in the independence of the Fed from the president and from Congress. And in this regard, I think this is not a situation where unlike Myers, which is the ultimate example, where the president's trying to arrogate some power away from the executive. This is a situation where Congress, political animals, one and all, knew better than anyone that the short-term temptations to lower interest rates and have easy money was a disaster in the long term, but was going to be irresistible. And so they tied their own hands by taking the Fed out of the appropriations process, and they tied the president's hand. And I think they tied the president's hand in a pretty significant way. And I understand the concerns about the balance, but I would say in this one context, it probably makes more sense to, and maybe you want to bring in a little bit of common law, and that's fine with me. But I do think you want to strike the balance so that the ultimate imperative is that the markets don't think that rates are being lowered for political pressure. When rates are lowered, the markets are going to understand that that's actually prudent financial management of our monetary policy.
In your colloquy with the Chief Justice about what a hearing would look like within the executive branch with the president or with the president's designee, I just want to make sure I have this clear. In that hearing, you could make legal arguments as well, I assume, not just factual arguments, but legal arguments to say, we don't think this rises to the level of for cause. Basically, the kinds of arguments that you've made here, you could make to the president in the same way in an impeachment proceeding. People make legal arguments to the Senate about what exactly is high crimes and misdemeanors, correct?
Correct. And obviously, the nature of the hearing is going to inform the scope for that. If it's, just half an hour with the president, I don't know how much you're going to get into sort of legal briefing. But if you did do anything like Taft, or you just said, well, we got a couple of ALJs lying around, we'll have one of them just sort of hear the evidence on this. Then I would expect there to be presentation on both evidence and law.
And just for the kind of simplest way, and this Justice Kagan was asking, to decide this case, I think one way would just be say there was insufficient process, and therefore we, at this juncture, deny the government's application. Thoughts?
I think that would be a very simple way to decide this case. I think perhaps the defect that was alluded to in the colloquy with the Chief Justice is that probably is also, the way that probably maximizes the chances that it gets back here on the merits, whereas if you decided to go a little further and say something substantive, it might bring all of this to an end. And there's probably some virtue to that. Certainly there's some virtue to that from my client's perspective.
Thank you.
Justice Barrett?
I'm going to ask you about irreparable harm. You were just talking to Justice Kavanaugh about the uniqueness of the Fed and its need for independence. And the government, because it has not challenged the removal restriction, for purposes of this case, I think we're all operating on that assumption. When the president, if you're thinking about the unitary executive, when the president has untrammeled authority to fire a subordinate, keeping that subordinate in office, I think, inflicts maybe a different kind of irreparable harm than the argument that the government would be able to make here, because the president doesn't have the same control over the Fed, at least based on the assumptions we have in this case. What do you think about that, and what kind of an argument would you make for, what is your best case argument that the president is not suffering irreparable harm by the inability? Let's assume that he has the ability to remove Governor Cook. Let's assume that some of your merits arguments are going to lose. They still have to show irreparable harm. So what's your best argument that he's suffering none?
Well, I think my best argument that he's not suffering irreparable harm in those circumstances is that he's not suffering the unique indignity of having sort of pure executive power exercised by people that are removable at will outside of his control. And that maybe that's a little circular in the end, but I think it's kind of why this case is, I think, problematic for the government, because they could have come in here and said, Fed Schmed, it's not that different. This is just like the FTC, and so we're suffering the same irreparable injury as in those other cases. But when they come in and say, no, we're going to accept that the Fed is different, at least for purposes of this case, and that we can't remove somebody just for policy disagreements, then having somebody continuing in office just because you have a different conception of for cause than they do, or than you've been able to persuade a court so far about, doesn't strike me as irreparable harm. And then on the other side of the ledger, I think there are enormous irreparable harms here that really don't have an analog in most of these other situations. I don't mean to denigrate any other agency, but there's a reason that monetary policy has been treated differently for these many years, and there's a reason that the markets watch the Fed a little more closely than they watch really any other agency of government.
Justice Jackson?
So you've had a couple questions about what good is a hearing? What would a hearing do in the situation where Ms. Cook has made a statement through her lawyer about the allegations. I guess I'm wondering, setting aside for a moment the standards for cause, don't we have to have a circumstance in this kind of situation in which the facts are established? In other words, I thought the work of the hearing, even in this situation, would be to establish when these applications were signed, what she thought she was attesting to, what actually was going on with respect to these documents that the president is pointing to that says, and he says they establish her deceit and gross negligence or whatnot. And I think before we even get there, we have to know what the facts are related to this. Isn't that what the hearing would be about, at least in part?
I think it would be, and maybe, though, to try to defend my, heads I win, tails you lose answer to Justice Alito, I mean, you could think about this by analogy. I mean, there's certain circumstances where you essentially grant a motion to dismiss for one side. You basically say, look, we didn't have a hearing here. That was a mistake. But even on sort of the best reading of the evidence, this is at most an inadvertent mistake. And so there is no for-cause removal, in which case my client would win. On the other hand, if, normally you have that kind of evidentiary hearing, and that is to establish sort of the facts, and then you then apply the law to those facts that have been established. But there are circumstances where you sort of don't need any more facts.
But then you're in Justice Kavanaugh's world, which is you would still at the hearing then go to the legal question of whether or not what you agree happened here counts as gross negligence. You would say it has to be at least that in order to satisfy the for-cause standard. The other side would say no. So there's some work to be done in a hearing.
Absolutely. And what another way of putting it is, look, the denial of the hearing to my client, if she does indeed have a right to a hearing, cannot be harmless error. Like, it just can't, no matter what you think of the facts. On the other hand, if you agree with us on the law, you could still resolve this case in her favor on the grounds that, there were two mistakes here. One, she didn't get a hearing, but we don't have to, remand for a hearing or any of the rest, because even on the facts kind of most, in the light most favorable to the government, this isn't a removable offense.
Can I go quickly to the standards? Because as I read the sort of what happened here, it wasn't as though the district court just sort of made it up in terms of what she thought should count as for cause. My understanding is that she was looking, as you've said several times, to the common law and what courts have traditionally said. And I see, for example, a Maryland court, Board of State Commissioners of Hagerstown, in 1903, which is around the same time as the establishment of the statute, that said, quote, "The phrase for cause must mean some cause affecting the ability or fitness of the incumbent to perform the duty imposed upon him." And other similar courts at the time talked about pre-tenure conduct and said if it was pre-tenure, it can't be sufficient cause unless it was serious enough to undermine the job performance. A mere allegation was not enough back at common law. It had to have been tested and proven, like through a conviction. So these standards that were used here to determine, at least at the district court level, whether cause was satisfied came from somewhere. Is that right?
Absolutely. And, I love that Hagerstown case because not only is it a very helpful common law case, but it's actually the basis for the definition in Black's Law that the government and Judge Katsas below relied on. I mean, Black's Law is an unusual dictionary. It just doesn't sort of, pop out the meaning from Noah Webster's mind. It cites cases for particular concepts. And the case it cites for cause is that Hagerstown case.
And so all the hypotheticals, I mean, we see them and they might be problematic, but they would be tested against the standards that the courts have applied, right?
Absolutely. And if I could just elaborate in one respect, I mean, if you think about pre-office conduct, there's only two kinds. One, there is pre-office conduct that was disclosed to the Senate in the confirmation process. And as to that, even the government sort of says, well, you probably shouldn't let the next president sort of relitigate all of that. And then the second kind is stuff that was undisclosed. And if it's as serious as we're talking about, that's essentially the nominee, defrauding the Senate. And so I actually think in that respect, impeachment is probably a more fit remedy than it might be in some other circumstance, because you're going to have whatever the conduct is, plus you're going to have the Senate being pretty darn vexed that was withheld from them in the confirmation
Final
process.
question. I took you to be conceding that there was notice here, and I guess I'm a little concerned about that. I mean, are you conceding that a posting on social media is sufficient notice in a situation like this when the president is seeking to remove a governor for cause?
So what I would say is, I think...
I know it happened. She got notice. We live in a world that is connected, but I guess isn't notice a particular thing in the common law?
Well,
or in our
put
law?
it this way. I don't sort of resist the idea that the Truth Social post is notice, because I think it's also fundamentally defective notice, because it's also indisputable evidence that the president prejudged the matter. And
right,
so it's not the kind of notice.
So hypothesize he didn't say you are fired or you should be fired. Hypothesize he just said, I have this information and I intend to fire the governor. Why wouldn't he have to send the letter to her? How is it that we can assume that she's on social media or has looked at the news, or that that's sufficient notice even if she did turn on the news and he's saying that? I don't know why that would be enough.
Look, I might make that argument, but that doesn't seem, if he said on Truth Social that, look, here, I have this allegation and I'm going to convene a hearing at, the Roosevelt Room at 4 p.m. tomorrow, please bring all your evidence.
What if she doesn't have a Truth Social account? She doesn't show up. Is that enough notice?
I think under those circumstances, probably not. But I think as a practical matter, in most circumstances, the president puts it on Truth Social. Most people, most of the time, are going to consider that to be notice. Again, part of the reason I'm not resisting is, or I'm, sort of moderating this, is because, this notice isn't the kind of notice the common law envisioned, because the common law would envision notice that didn't prejudge the matter.
Thank you.
Thank you, counsel. Rebuttal, General Sauer?
Thank you, Mr. Chief Justice. Turning to the question of whether or not in-office or pre-office misconduct can constitute cause, I want to make a statutory point, which is that the INM standard is, on its terms, limited to in-office misconduct, and Congress did not adopt that here. They adopted the more capacious standard, as this court recognized in Collins against Yellen. Cause gives the president more discretion, provides less protection to the officer than the INM standard does. And even if we were in a situation where you're looking at the 19th century case law and so forth, they disregard a series of cases that hold that pre-office misconduct is sufficient cause. For example, in Ray Gooden, from New York in 1902, which involved an officer who engaged in a kind of shenanigan in order to get the office in the first place. There was a corrupt agreement to appoint somebody to a position if they supported that person politically. Iowa against Walsh, which was pre-office embezzlement. Gill against Watertown, a case they rely heavily on. It was said in dicta, at least, that gross frauds committed before office would constitute cause to remove. So there really isn't support anywhere for this notion that pre-office misconduct can't be considered when it comes to a cause standard. And related to that, I thought it was very telling that Mr. Clement was saying that if it does come to pre-office misconduct, impeachment would be the only remedy that would provide it, which, if taken to its full extent, would make governors of the Federal Reserve have the kind of tenure protections that the Constitution affords to Article III judges. That is not what this statute says. That is directly in the face of the statutory language, which says cause with no further restrictions. Clearly, Congress envisioned that they could be removed for a good enough reason. And on that point, I just want to emphasize there's this colloquy about whether it should be sent back or decided now in the merits. Whichever way the court comes out on that, the court should send it back with an emergency stay. And I want to emphasize two reasons there. This court, no court should hold that the misconduct that's alleged here, which is at least gross negligence, at least an inadvertent notation that is a grave misrepresentation on a mortgage document that's designed to determine the governor's interest rates is not cause to remove a principal officer of the United States who sets interest rates for the entire country. So all the discussion of what are the outer bounds of cause, where is judicial review, on that fundamental court, neither this court nor any other court should look at this and say, this is likely not cause. That sends the wrong message to the markets. It sends the wrong message to the American people who have to make correct representations to their banks when they're getting their mortgage interest rates. And the second point I would make is the remedy granted here, a preliminary injunction that runs against the president, reinstating a principal officer of the United States, is something that has never been granted before 2025 in this court or in the nation's history, and in fact contradicts a clear holding of this court in Sawyer that a preliminary injunction is not available in equity. Those two reasons alone clearly suffice to send it, if there is going to be a decision to send it back with the emergency stay that we've asked for. And then if the court decides to sort of send the case back to have many more of these issues that we've discussed today to be aired, we would urge the court, and I think Mr. Clement wouldn't disagree, to direct the lower courts to proceed very expeditiously. Here, we are in an emergency stay posture. The executive has been suffering irreparable harm since early September, and the sooner that these issues are resolved, the better. Thank you.
Thank you, counsel. The case is submitted.
yes, 92%. I said, you didn't have to be that specific. But I said, you're rich. Yes, I'm rich. But he just announced he's going to do $10 billion worth of plants. I mean, it's amazing what's going on. Look, it's amazing. We've never had anything like it or close. Nobody else has either. So I think in terms of your investments, you're in great shape. I don't even ask anybody how you're doing now. It's like everybody is making so much money. Oh, look who I see, Tim. Hi, Tim Cook. He's been good for 650. Think of it, $650 billion. Okay, can you imagine? That's what he's going to be investing. More than that. I think it's going to end up being more. He's great. You know, he's great. He's done some job. You have done really some job. And we have so many people in this room that have done a job. I don't know how many have done better than Tim, but some are right up there with you. You better get your ass moving, I'll tell you. But fantastic people. Fantastic people. But I go around and I say, meet the biggest people, biggest business people. I say, congratulations. They say, on what? I said, you've doubled your net worth since I've been president, right? He said, yeah, even more than that. They would say even more. We're doing even better than that. And, you know, we've given you a platform where you can really put your genius to work. We have a lot of brilliant genius people in this room, and you can put that genius to work. And it's an honor to do it. In a way, I'm jealous. In a way, I'm upset. A couple of people in the room, I can't stand them, and they've become very rich. There's nothing I can do about it. I would screw them if I could, but I can't do it, right, Dina? I can't do it. I would, if I had a chance, if I could just take them and say, you can't do what Apple's doing. But you're not allowed to do that, Newt Gingrich, right? We can't do it. But I would love to do it, really. You know, it's one of those things. But everybody's making a lot of money, and everybody's investing money in the United States, and our jobs are through the roof. And I made a statement the other day, thank goodness for robots, because we're never going to have enough people to run all these places that are being built. And I think robots are actually going to be a very big business. I think it's going to be surprisingly big, but I think we're going to need it. We're going to need it. So we have a country that's becoming very safe. We had the best crime numbers that we've had ever in recorded history. Perhaps they were better 100 years ago, I'm not sure, but the recorded history is 67 years, and in 67 years they're the best numbers, and that's despite having a lot of people in the country that shouldn't be here, that we're getting out. But we've got tough law enforcement, smart law enforcement, and patriotic law enforcement. You know, they've been amazing. One example is Washington, D.C. You couldn't walk down the street in Washington. You get mugged, you get killed. They were losing 100 people. Think of it, 100 people a year, and dead. You call up the parents. They come in from Iowa. They come in from Indiana to see the Washington Monument, and they end up being killed. It's not happening anymore. And I said in the other room, people are going to dinner. They're meeting their wives in the middle of the street, and they're walking across the street to have dinner. New restaurants are being built at records that nobody's ever seen. They were closing. We lost half of the restaurants in the last 4 years during the Biden administration. Now they're all opening again. I even went to have a dinner just to show, I guess, to make a point. I went to a restaurant in Washington. I walked right down the middle of the street. I wouldn't say that Secret Service was thrilled, but if I did it a year before, believe me, it wouldn't work. Here's my other friend, Hussein. How are you? Okay? Are you good? Boy, you got a lot of good people here. This is a very good place. But so it's amazing what's happened there. Memphis is amazing. When you go to Louisiana, what we've done there has been incredible. Always much more helpful if we could have a little participation. In the case of Louisiana, we have Jeff Landry, the governor, Republican governor. We have a couple of Democrat governors. We have a couple of Democrat mayors who very quietly are begging us for help, and we're making them all look very good. But I would do it. If I were a Democrat, if I were a mayor or a governor, I'd be saying, Mr. Trump, could you quietly come over here, and would you do this, President, for me? Send about 1,000 troops in here, and we do it fast, and we get rid of the criminals, and it's amazing how effective. You know, I didn't campaign on this. I campaigned on law and order, but I didn't know it would be this type of law and order. But the cities, some of these cities, we've lost these cities, and we're bringing them back, and we're bringing them back quickly. Washington took us literally 6 weeks to make it safe, and 8 weeks to make it really safe. And now it's really safe. And I don't know, some people disagree, but I like seeing those big, strong soldiers. We won in the Supreme Court a very important case, merit. Our country was built on merit, and then all of a sudden we got away from that. And people with A averages and high college boards and everything were not able to get into colleges, and people that had C averages and low college boards were getting in. And, it's not fair, but our country is based on merit. The whole concept and the whole system only works on merit. It doesn't work on anything else. And our military works now on merit. And when you see the soldiers in the street in Washington or in Memphis or in New Orleans or in some of these places, including Chicago, we have crime down in Chicago, despite the fact that we have an idiot governor and a mayor very low IQ person. He's a low IQ person. And it's amazing. You have these wonderful, beautiful black women with Make America Great Again, MAGA caps on. They're all over Chicago. They want MAGA to come in. And we went in a pretty quiet way, as opposed to the way we did it in Minnesota. In Minnesota, we took out over 10,000 hardline criminals, people with big convictions that came in here that shouldn't be here, brought them back to countries. In some cases, we bring them to jails, because if you bring them back to the country, they'll find a way, despite the strong borders, they'll find a way in, because a lot of them are really evil, but they're not stupid. So we're doing a real job. The country's the hottest country anywhere in the world, the best place to invest. The great big beautiful bill is incredible. You get that 1 year deduction, you build something and you take the whole thing down. And I always said that's what made my first term so successful, because, people were buying things that, I have a friend bought an airplane. He never used it. He just bought it. He said, I deducted it. He's on the plane. I think he's got, Steve, you could buy it. He's got about 4 hours on the plane. It's been 3 years. I think it would be a great plane to buy, actually, because he'll never use it. But it really spurred people to do things and do projects that they really would have delayed or held. And the beautiful thing about the great big beautiful bill, the one that we just did, is over there you had a 2-year window to do it. Now we have a 10-year window, which I hate to tell you, because people will take their time. So in one way, I didn't want that. I call that not good, but it is good ultimately. Think of it, it gives me a chance to use it if and when I ever get out of this position. There's a big question. It gives me a chance to use it. Otherwise, I'd be precluded. That would be terrible, right? But it's 10 years, but you're able to, you build something, you build a factory, you write the whole thing off 1 year. Nobody's ever thought that was possible. It was always 38, sometimes 40, sometimes 41 years. You get a little here, a little there, nothing. You write it all up. So it's been really amazing. And you are the people that made it happen, really. Largely it's you and a group of others. Not a lot more. The people here, I guess because of Larry, the people that came to this event, it's really incredible. I wasn't sure how it was going to turn out. We had somebody, as you know, that ran it for many, many years, and I'm not sure what happened there, but I figured, well, that's all right. They had a hell of a run in Davos. Then I heard Larry was taking it over, more or less, and he called me. He said, would you do me a favor? Would you be there? And we've had some great business dealings together, and he's great. He's one of you. He's one of the greats, and it was an honor. We had a good speech. We got great reviews. I can't believe it. We got good reviews in that speech. Usually they say he's a horrible dictator type person. I'm a dictator. But sometimes you need a dictator. But they didn't say that in this case. And no, it's common sense. It's all based on common sense. It's not conservative or liberal or anything else. It's mostly, I'd say 95% common sense, and that's what we have. So I just want to thank everybody for being here. It's such an honor. And if we can ever help, you're going to let me know. And I have a pretty direct line. Marco Rubio's here, too. He's done a fantastic job as Secretary of State. He'll go down as maybe the best Secretary of State if he keeps going like he's going. That's a big question. I don't know that he will, but for the first year, he's headed to the top. And I just want to thank everybody very much for being here. Thank you very much. Take care of yourselves. Thank you.
And Houston, station on 2, looking for your go in step 5.1 of the AGA battery ops.
Copy, Chris, and your go.
And Houston, station on 2, the AGA battery recharge ops are complete.
Copy, Chris. Thank you.
And Houston, Chris is with you on 2 for the WSS changeout.
Thanks, Chris. Yeah, so in our telemetry, we believe we're seeing a small air leak from the WSS, and so we'd like to ask you to please recycle both the air tank hose and the compressor port tank connection on both tanks 1 and 2, and then we'll re-perform our ground checks. If you need a procedure reference, in that WSS swap procedure, steps 1.7 for the disconnect and 2.3 for the reconnect.
Okay, yeah, no worries. I will go ahead and recycle both the air and water connections for tanks 1 and 2 on both of those. I'll do that momentarily.
Awesome, appreciate it.
Share with each and every one of you. Station is in good hands with Chris Williams and 2 Sergeys, and we are continuing on. And we got to see our Crew 12 friends that are going to be launching really soon, and they were there when we stepped out of the plane at Ellington, and it was really nice to see them. We were hoping to give them hugs in space, but we gave them hugs on Earth. It all works out. Space station is going super strong. I'm very proud of the space station that we built and what humans can do. But how we handled everything all the way through nominal operations to this unforeseen operations really bodes well for future exploration. We're a well-honed machine here at the Johnson Space Center and around the world. So when we're getting ready for Artemis, I am very optimistic. So, sumimasen. I talked a lot, but go ahead. Thank you for your hard work.
Thank you. Yeah. Gina-san, also Mike-san explained a lot, and I mean, almost nothing to add, but thank you very much for this opportunity to talk about our great experience to everybody. And I'm so grateful. I was the member of this great team. And of course, we came back a little bit early, but we worked very hard, worked together and helped each other and also accomplished a lot. It's actually not only our crew members, but also including ground, and also everybody actually helped us a lot. And I think this is great because I think we showed everybody about international cooperation, importance of the international corporations. And this is kind of like a bright side of humankind, where we can work together and accomplish very good. And also, this is kind of like a good vector to a bright future. So I think we were able to show us like a good example for everybody. And we are going to keep talking about our great experience. And hopefully people think actually our bright is bright, so bright. If people believe that, actually we can accomplish that. And if we're gonna actually keep working on that, even on the ground, I'm going to keep talking about our great experience. So thank you very much for your support.
Hello, everybody. I was really happy to be as a part of Crew 11. I had and I have super awesome crewmates: Zina Sensei, Michael San, Kimiya Sensei, my commander, pilot, and me in this crew. And also I would like to say for you, thank you very much for your help and support during preparation, during flight, and I'm really happy. It was unbelievable, unforgettable increment for me. It of course was a first flight for me, and I'm happy to have you with me during this flight. And also I would like to say thank you very much for this opportunity. Thank you, my country, Roscosmos, NASA, United States, and SpaceX. It's super opportunity for me to have this flight. And also thank you very much, ground team in the all MCCs, Moscow, Houston, Tsukuba, Munich, Huntsville. Thank you for your great work and support. And thank you very much, everybody.
All right, thank you. And with that, we will go ahead and open it up for questions beginning here in the room before going to the phone bridge. As a reminder for those joining us on the phone bridge, you can press *1 to enter the queue and *2 to remove yourself from the question queue. When called on, please state your name and affiliation, as well as to whom your question is addressed. And with that, we will begin here in the room.
Thank you. I'm Mark Carreau with Aviation Week and Space Technology. With the space station nearing its end of life, I know there's been a lot of discussion about trying to get as much done as possible that you can do up there. And you had a pretty full agenda. I'm just wondering, even though you left a little bit early, do you feel that may have subtracted from the ability to do everything, or did you really charge on and get as much done as you could and leave? I know there's only 3 now for just a little bit, but do you think the desire to get as much done in the research and tech development will be interrupted very much by what happened?
So if I could just take that one. Our crew was a very productive crew, and our ground teams were amazing because they balanced everything based on what we could deliver, and to make sure that we had enough rest. And it was a very nice pace, and it was a lot of things to get done. And yes, we left, we came home about a month early, and that is going to affect the timeline a little bit, just because there aren't 7 people, there's 3. And but what's really neat is that our replan capabilities are great, and we're not missing anything that had to be done time critically. We're able to move things around. We still have 3 cargo ships on the USOS side, and I think 2 Progresses on board. So there is still a lot of unpacking and packing to do, just for the cargo operations. Not to mention, all of the science and everything else. We left a really capable crew on board. Sergei Kuznetsov is a great commander. Chris Williams came up and with great enthusiasm and willingness to learn. So we're in very good hands. Yeah, there's going to be a little bit of a difference in schedule, but we're going to be able to accomplish everything we need to do. When Crew 12 arrives, they're going to hit the ground running. But again, we have this down to a really nice system where our mission control teams, our planning teams, the space station program, all kind of take a good pulse and give us as much work as we can do. And we as crews try to deliver, and there's flexibility in the schedule, and that's what keeps the space station going. And yeah, there's still some more years left in our beautiful space station.
All right, thank you. We'll go ahead and go to the phone bridge for a few questions. First up, we have Anthony Leone with Spectrum News.
Hello, everyone, and thank you so much for taking our calls and questions today. what happened up there? What type of suggestions would you recommend for future missions? And would each you, if you could you want to go back just to finish the mission the way you were hoping to? Thank you.
I hope to go back to ISS for so many reasons. It's just an incredible experience. And I think even though we had an unexpected timeline, there's so much that we are proud of and so much we did accomplish. Like Mike mentioned, we welcomed so many visiting vehicles. We had every single docking port full at one point while we were up there, which is just absolutely incredible. So we got a lot of research done, a lot of cargo transferred, setting up the space station for really the rest of its incredible career. As far as things we would do differently, I am very proud to say that we were as well prepared as we possibly could be, and that's thanks to a lot of really excellent training that we get on the ground, and just being up there with really excellent operators and people who come together as a team really goes a long way. And that's the crew on orbit as well as our ground support teams.
All right, next up on the phone bridge, we have Jonathan Seri with Fox News.
Thank you so much for doing this, and welcome home. For Zena and Oleg, how did your first space flight live up to expectations? I know you worked hard to prepare, but are there things that you just have to experience firsthand that stood out and surprised you? And for Mike and Kimia, how did your first flight on Dragon compare to the space shuttle?
For me, one of the surprising things was almost how unsurprising it was, if that makes sense. I felt incredibly well prepared thanks to all of the excellent training that we get here at Johnson Space Center, at our international partners, and at SpaceX. Of course, there are some things that you just have to experience for yourself, but for me, those were all a thrill and a joy. I actually enjoyed re-entry even more than launch. It was a lot of fun, and I'm very grateful that I got to experience that with this crew specifically.
I absolutely agree with Zena. Launch and re-entry was super amazing and active time. It was nice, and I was surprised how our Earth, our planet, beautiful, and it's most beautiful when we can see on the picture. I was surprised. It's big difference between picture and real view from Dragon's windows. What I saw first time after ascent, and no, I think that's all. And I also was surprised how my crew is great.
Shouldn't be big a surprise.
Yeah.
Yes. So last flight was like by Soyuz, and this time as a Crew Dragon. I was so surprised actually. Crew Dragon flight was so smooth and very comfortable, and just like future, like a touch panels, like a very, cool future-looking, nice like a suit. Yeah. So I really enjoyed, but just differences. So I really loved actually both experience. So landing on the hard surface, that's also good. A little bit harder landing, but no shaking after landing, that's also good. Softer landing, but after landing, shaking, that's also good. So I really enjoyed. Thank you.
So between flights, I from Soyuz and Space Shuttle, I helped worked with the commercial crew program, and I was really glad to fly on Dragon. Of course, Kimia-san and I were at one time going to be on Starliner. That's still going, but Dragon, wow. All the way from the launch, it was you could feel the Falcon 9 talk to you, and all the way up. It was hard to hear the Falcon 9 though, because I think there were some shouts of joy and giggles and things going on as we were launching and enjoying the experience, and that's such a human thing. And then coming back, Zena, Commander, made a brilliant choice of turning down the lights so we could see the plasma through the windows and orange glow. And I will say that it was the shuttle came in very benignly with its profile, and it was more of a pink glow. Soyuz has an ablative heat shield that really speaks to you with lots of different kind of fireworks, not in a very, very good way. It works great. And then and Dragon was somewhere in between. We hit 5 Gs on the way down, which the guy who flies fighter airplanes in me was like, yeah, this is it, when I could breathe. And then the splashdown was my first splashdown, and it was very nice. Yeah. I like splashdowns. So it would be great to compare notes with the Artemis crew when they have their splashdown, and we can compare splashdowns. And not very many people at the astronaut bar, space bar, right, will be able to compare splashdowns anymore. So this is going to be fun. And what a great crew. Hats off to you, Commander.
All right, next up we have Marcia Dunn with the Associated Press.
Oh, yes. Hi. For Zena, you were just one day away from making your first spacewalk when it was called off. How crushing was that? And also, if one or more of you could just talk a little bit about the medical equipment aboard the space station and how it did or didn't prove useful. Any recommendations on future first aid kits?
Yeah, for me, of course, spacewalking is something that we all train for, and we had multiple crew members on board who were qualified to do a spacewalk. It was absolutely something I was looking forward to doing, but it's also something that's completely out of our control. We just finished an expedition that did not have any spacewalks, and even though someone like my classmate Johnny Kim was incredibly well prepared, simply didn't have the opportunity to do a spacewalk. So it's actually not about any individual. Spaceflight is much larger than any single person, and in the moment you're not really thinking about me and this thing that happened to me. You're thinking about the mission and your crew, and NASA made all the right decisions. In my opinion, this is a really excellent example of risk analysis and decision making, and I'm very proud of the decision they made.
Just to add on to that just a little bit about the equipment, one of the things I remember from Expedition 9 is we just started working with ultrasound machines, and I think the ultrasound technology has gotten better on planet Earth, and we've taken that into space. And having a portable ultrasound machine helped us in this situation. We were able to take a look at things that we had and didn't have, and all of my crewmates, we got so much experience with ultrasound in looking at human bodies as we change over time as part of science and medicine. So when we had this emergency, the ultrasound machine came in super handy. So I'd recommend a portable ultrasound machine in the future for sure for all space flights. It really helped. Now, of course, we didn't have other big machines that we have here on planet Earth, and maybe some of those can't be in space. And we do try to make sure that everybody before we fly are really, really not prone to surprises. But sometimes things happen and surprises happen, and the team was ready. And that was, like Zena said, preparation was super important.
Next up, we'll go to Robert Perlman with Collect Space.
Thank you. A question for Mike and one for Zena. Mike, once it was decided that you and your crewmates were coming back early, did it become sort of a scramble to get packed up, or did you forego or abbreviate what you normally pack for the ride home? And for Zena, at the very start of the mission, we all got to very briefly see your zero-G indicator and heard that it was related to a shared experience with a SpaceX training member. Can you now elaborate a bit more on why a SEAL and what that experience was?
So we had made a promise to ourselves as a crew not to be last minute in getting packed and prepared. Fortunately, we had enough time to make sure that our Dragon was ready to go, and in a few interstitial spaces we were able to make sure that we had our things packed and ready to go home. And I think because being ready a little bit ahead of time, Zena says, I don't like doing stuff at the last minute. And we all agreed with her. We listened to her. And those are true words of wisdom. So we weren't super rushed, Robert, but it was definitely, we were focusing on the things of making sure we as a crew and our Dragon were ready to go and that we handed over any last minute pearls of wisdom to Chris and to Sergey and Sergey.
Yeah, for the zero-G indicator, forgive me, I won't read you in on the exact inside joke, but it is a shared memory with our SpaceX lead trainer, Paul Weiss, and that whole training team who got us ready for this flight. And Paul was actually also my lead trainer for Crew 9 and that lead up. And so he has been just such a steadfast friend and excellent trainer getting us ready for this space flight. So we really felt like Paul was with us in the capsule, and we very frequently said, let's make Paul proud with our actions and our decisions, and I hope we did. So thanks, Paul.
We will take a quick question from social media. @Dewani2 on Instagram asks, what did you miss most about Earth?
Oh.
What's Emilia?
Certainly the people.
You didn't miss me. I was there with you. So what else did you miss?
You were first. I just forgot.
All right, next up we have...
Oh, no. Okay, I'll say what everyone missed. Kimia-san missed hamburgers and french fries. We talked about this.
You are as well, right?
Yes, yes, because I complained about missing hamburgers and french fries. And Oleg, I think you missed your beautiful wife, Irina.
Absolutely.
And and Zena, you missed a lot of things, but you were, I think, born to be in space.
I was pretty happy there, but
Yes.
I did miss ramen.
Yes, and any kind of noodles became ramen, even if they weren't really ramen. We called them ramen.
All right, next up we have Will Robinson-Smith with Spaceflight Now.
Hey, everyone. Thank you for taking the time to speak with us today. Question to Mike and potentially Kimia, if you'd like to chime in. Mike, you briefly touched on Starliner, and in your time on orbit, both of your colleagues who flew the CFT mission, Butch and Sunny, announced their retirement from the astronaut corps. So, given that you and Nicole Mann are the last two, correct me if I'm wrong, but remaining NASA astronauts who have been trained on Starliner, at least publicly announced, do you envision that once Starliner is ready to carry crew again, you might be a part of a future crew? Is that too early to ask that question, or how do you kind of see yourself moving forward with that part of the commercial crew program? Thanks.
Yeah, that's a great story about Starliner and where we are with that, and we're wishing Boeing and the commercial crew program some super success in getting Starliner. It's really in NASA's interest to have two partners that can fly spaceships, and the more people flying in space, the better off we are. I think we are just focusing right now on rehabilitation and getting back and getting maybe back in line because it was such a nice ride, and we'd like to get back in line again. But in the meantime, though, there's a lot of capable astronauts, and I think we're all we'll figure out who's gonna fly the next Starliners. But at some point in life, if they ask you, you wanna go fly, of course, it's hard to say no. In the meantime, if I had a chance to fly with any one of you again, I would immediately say yes. I'd cancel any retirement plans and get right back at flying. This is such an amazing crew, and Zena was right again about it's not when, but with whom. And Yui-san, shall we go fly Starliner? What do you think?
Yeah, I really want to. I really liked actually training in Starliner, and also really liked the design concept. Yeah, very capable. So of course I would like to fly as Starliner on Starliner. But on the other hand, JAXA has less slot actually to send JAXA astronaut to ISS, and I just want to support actually young astronauts to go to ISS. So yeah, probably this flight might be a last one. So I just want to support other crew members. JAXA astronauts from ground. Thank you.
All right, next up we have Joey Roulette with Reuters.
Hey, thank you. Question for Kimia and Oleg. I'm curious to hear what you two think about being part of the first kind of medical return from the ISS, and did either of you help or play any role in managing this medical concern? Thanks.
Okay, thank you for the great question. Actually, for me, I was so surprised, like training actually works very well. And also ground, including, everybody, crew members, and also ground team works actually well prepared, actually, training-wise. So we can handle anything, including like planning, replanning, everything. But so I was so surprised, actually, because of the 25th of history of ISS operations. We are very capable. And if we use this kind of experience, actually, our future human spaceflight will be very, very, actually, we can handle any kind of difficult situation, I thought. So, of course, we came back early, but including this kind of decision, this is actually very, very good experience for the future human spaceflight. Thank you.
Next up, we have Manuel Manzotti with Exploration Especial.
Thank you so much. Manuel Manzotti from Exploración Espacial. I cover the space program in Spanish. Two quick questions. The first one, with any one of you who can answer, because I don't know who was particularly involved, about this edge computing experiment developed along with Red Hat and National Lab of Axiom Space. Could you go into details on how it was implemented and what kind of information of data was used in order to perform the experiment? And then a quick question for Zena. Could you finally, did you find the time to write some poetry?
Oh gosh, I found time to read actually a lot of poetry. For me, it takes time for an experience to percolate, but I'm sure I'll be writing a lot in the weeks and months and years to come.
And as far as edge computing on board the space station, I don't think we were involved with the actual computations. What we did was we were a little bit like IT support and made sure that the computers had the power and connections with the Ethernet and the communication so everything could work. Sometimes, especially with commercial payloads, we aren't as super involved to know exactly what the results are, but I'm sure our friends at Red Hat and the rest of the team, we tried to make sure that all of our payload customers were happy and that we did our very best to help them. So I'm sure edge computing was pretty interesting, but we haven't heard the results yet.
And we will come back here in the room for a question.
Richard Tu with the Post newspaper. Mike, a quick question for you. Last time we were here, we talked about amateur radio and your interest in that. And it's a very good answer you gave me at that time. I'm curious, in the time that you were up there at this time, were you able to participate in any events related to amateur radio? And were any of the experiments RF-based that you worked on?
Yeah, so I was super excited and still am with amateur radio. What was interesting and what I was really proud of is that all my crewmates participated with our school outreach, and we salute the ARIS team for sharing spaceflight with people all over the world. I think I talked to a school in Africa. I think you had one in Japan and South America,
Yeah, South America, Central America.
Yeah.
I had one contact with a research ship that I worked on briefly, which was really special.
Yeah.
That was very cool.
And we didn't, I personally let myself down a little bit and not having too many random QSOs out there, but we did reach out and have a chance to talk to people across the planet in whatever language, because that was a fun thing. There were some neat experiments also, especially on Russian side, and with some extra video, and we were definitely used to, I guess there was some TV side on in Columbus module. Mm-hmm. I will say, just looking back at it, my first experience with amateur radio, it was all in the service module. We could actually look down through the windows of service module and kind of see where we were talking with. And Columbus doesn't have a window, so it was a little harder to imagine. So we put up a world map, and you could see where you're getting into range and out of range. But also you can just imagine what it must be like at some of these places that we could talk with. And I think if we had that extra month or so that we came, I would have liked to think that that version of me would have reached out on the radio and talked a little bit more. Maybe next time.
We will go back on the phone bridge. We have Shannon Perrine with WTAE Pittsburgh.
Hello, everyone. Yes, it's Shannon from the ABC affiliate in Pittsburgh, and I will say Pittsburgh welcomes all of you home back to Earth, but a special hello to Michael Fink. Here's my question. What do you say that in your time, though it was truncated in space, you were able to do to advance the cause and mission of science on Earth in your time there? And I'd also like to ask how you all are feeling right now today.
Well, Shannon, thank you for the Pittsburgh welcome. And how Yin's doing? And we are really, it was great to be back up in space. I'm super proud of what we've accomplished in science. Yeah, we were truncated, but 5.5 months is a long time to get a lot of good things done. One of the things that comes to mind is our stem cell research. That's just going to make things better. When you take gravity out of the equation, cells can reorganize themselves in some really amazing ways, especially with stem cells. They can be anything. So we're thinking that there's a nice future for not just the International Space Station, but for commercial space stations to help with medicines and actually human-grown organs and organelles that can really help with help people who are sick on the ground. And Pittsburgh's a great place like that. We are at the forefront of a lot of medicine, and there's a lot of room in the space program for research from, from one of my favorite city.
All right, next up we have Sophie Sanchez with Cosmic Chicago.
Hi, thank you for taking my call. Over the years, we've seen how different anomalies lead to new training and procedures. I know it's early days still, but can you share if you have any ideas how your unique experience might translate into new training for future astronauts? Is there anything new being discussed already? Thank you.
I don't know what new is being discussed already. I'm very sure that we will have a lot of great lessons that we can take away from this experience. I already feel very confident that we get really excellent training, especially for any kind of urgent situation that might arise. We're really well trained to get a situation stable. Beyond that, I think the farther afield we go as we journey beyond low Earth orbit, having tools on board to diagnose and treat a myriad of situations is going to be a really interesting problem to solve. But while we're in low Earth orbit, I think we were as well set up as we possibly could be, and I'm really proud of the way the team reacted. So I would not actually want to train any differently than we already had.
Next up, we have Ryan Kiton with NASASpaceflight.com.
Hi, thanks for doing this. Welcome back to Earth, Ryan Caton, NSF. I was just wondering, usually when the crew transfer happens on orbit, it's to my understanding that the outgoing crew will hand over some advice or some other words to the incoming crew. So I'm just wondering if you'll be doing that with Crew 12 on Earth rather than in space. Thank you.
Yeah, we want Crew 12 to hit the ground running, or hit the space floating, something like that. I think all of us have some really good perspectives. I think Zena and Oleg can help especially the new flyers and on what to expect. I think my only advice to them, just as we did with the change of command ceremony, was take time and stop for a group hug.
Group hug and selfies.
And selfies.
He was great about photos. And Crew 12 is not arriving to an empty space station. They have Chris, Sergey, and Sergey there, so they will get lots of handover. As far as Dragon-specific stuff, that's something that we're happy to talk to Crew 12 about, and they're getting really great training in Hawthorne right now.
Next up, we have Claire Cameron with the Scientific American.
Hi there. This goes to anyone in the crew who wants to answer. What were some of the biggest challenges that you faced during the course of the mission, aside from obviously the medical issue that prompted your return? And then also, what were some of the science highlights whilst you were in orbit? Thanks.
Oh. Not enough hours in the day to take photos. That was one challenge. There's just so much to share and to do and to see, and I think I could stay there for 18 months and still feel like I didn't have enough time. Yeah, I think that was one of my biggest challenges. There's just so much to see and experience.
And it was all wonderful. I mean, seeing the Earth from so many different aspects, getting a chance to talk to people from all over the planet.
Absolutely. And so many really interesting experiments that we got to take part in. Some of them are experiments where we're tracking our own human bodies and how they adapt to the spaceflight environment. I come from a life sciences background, and so I really loved all of the chances I had to work in the life sciences glove box. Of course, I'm very familiar with pipetting small volumes of liquids from one vial to another vial, but I'm not as familiar with those liquids kind of clinging to the tip of your cannula and trying to crawl out of the tube that you're trying to put it into. Some really interesting quirks of working in this weightless environment. But again, the farther afield that we start to go, the more we're going to need astronauts to be the eyes and ears and lab notebook for the researchers on the ground. We're not always going to be the scientific experts. In fact, we rarely will be. And so I think the ISS has been an excellent proving ground for how we get science done and also involve a mission control team that includes scientists and the experts here.
Yeah, super collaborative.
We will come back in the room for a couple of questions.
Oh, thank you again. I'm Mark Carreau with Aviation Week in Space Technology, and I wanted to follow up on an earlier question I had, and I think this is for Mike or Zena. But Mike, you spoke confidently about not falling too far behind because of the training and the flexibility and the people who are going to follow up with the space. Well, one of the things you're going to do at the end was a spacewalk to kick off, I think, the 7th IROSA, to get 8 installed in all, to give the station adequate power for a whole lot of activity, and then for the deorbit. Do you feel as confident that they'll be able to catch up? And I think they're try to look at the end of this year for the spacewalks to at least receive both and maybe get the 7th or 8th installed. But, there's time. I just wondered how confident you feel they can move ahead.
Yeah, we floated on the shoulders of giants. The previous crew had started the IROSA work, and so we were able to consult with them and figure out how to continue on with the IROSA work. And I think similarly, the next crew that gets to go outside, we have those bags. They were really well packed and ready to go.
They're ready.
The procedures were scrubbed, and we'll work with them, of course, as their friends on the ground. I do believe, Mark, like you said, is that, again, I can't speak for the program, but I do think that the space station program has some flexibility. These weren't the immediate things that needed to be done like we had, 8 or 9, 10 years ago with when we had a leak in our thermal control system that had to be done immediately. So I think there's some flexibility in getting the job done. I'm just really amazed with all of the variables, how well that our teams on the space station program side and the flight operations director at FOD side, how well we can come together and make a new plan. We had a really great plan, didn't work, so we got a new plan coming up, and I do think that there's some flexibility, and it will be great to help our teams, at least from what we can do down here, to make sure they're successful. And the space station will just keep going. It's a wonderful, amazing space station that we've built, and it was just a real joy to be back on board.
We will take another question here in the room.
Gina Sunseri with CBS News. The briefing before your spacewalk that didn't happen, they talked a little bit about the new solar arrays, but sort of threading this needle between maintaining the space station but getting it ready to deorbit. Did that make your time up there a little bittersweet, thinking, so many good memories here?
I don't think I got to experience the bitter part of it. It was really, it was all sweet for me. It was really special to get to see the space station. I don't know if all of our active astronauts right now will get to see the space station. And so I'm so grateful that I got to, and that I got to be there with people like Mike and Kimia who have been there before, and Mike especially, who has been involved in constructing the space station from its infancy, really. And it's been such a marvelous, collaborative, incredible piece of human engineering and collaboration, and to have our international partnerships there. I'm just so grateful that I got to see it.
We will take a couple of questions from social media before popping back to the phone bridge. At Sean Vecchio on Instagram asks, what was your favorite moment from your mission?
Ooh, all of them? Can we choose all of them?
Yeah.
Oh gosh. Yeah, there's a lot to choose from. One really special one for me was celebrating New Year's with the crew. It was, off-duty time for us, and we all gathered in the service module, the entire crew, our Soyuz flyers and Dragon flyers, and just being there together as family, and then calling each of the mission control centers as they at home were experiencing their local New Year's Eve. It was just really heartwarming. I don't know how else to put it.
It's such a human event.
Yeah.
One of my favorite times, I liked all the times, but, and I think Kimia and I especially shared this because we knew how wonderful a feeling it is, but when Oleg and Zina, passed the Kármán line, and we got to see Earth for the first time, and became a real cosmonaut, and you instantly turned into a veteran astronaut right there, a flown astronaut for sure. We were so happy for you both. It was just a really special time to share that joy with you.
I was giggling a lot.
I thought that was Kimia. Oh. What was your special time, Kimia?
Yeah, for me, like JAXA's, Japanese new cargo vehicle, HTBX, came successfully, and everybody helped me a lot. So yeah, that was a great moment.
Yeah, Kimia reached out and grabbed it with the robot arm, but his arms are so long.
Yeah, very long.
We were thinking that if the robot arm broke, he was still just going to reach out and grab it.
Nope.
Oleg.
For me, all our parties was a great time, and one moment also I like it was a moment when new Soyuz crew came to us, and it's new people, and I was really happy to see new people on the station.
Thank you for that. And at Nils122000 on Instagram asks, what was your favorite aspect of having free time on the International Space Station?
Oh, just looking out the cupola for me, taking pictures. Absolutely. Yeah, that never got old.
Yeah, we had some free time, but not a lot. And I enjoyed free time when we, like we mentioned, is we had some time to spend together as a family. And my first mission, we only had 2 people, and it never got old. But it was really cool having 7 people. And the times that we spent together, we made sure that we had meals together at least once a week. Sometimes we did it more. I think there was one week where we had special space cakes, 3 cakes in 1 week for all kinds of celebrations and milestones in people's careers. So those kind of things. Yeah, and I think that's one thing that was definitely new was space cakes. Yeah. My first flight, and we would just get a cookie and put some icing on it, and that was good. But they got better.
We will head back on the phone bridge for another question from Joey Roulette with Reuters.
Hi, thank you. I just had a quick question, hypothetical question about NASA's astronaut medical privacy policies. If the astronaut who suffered the medical issue wanted to identify themselves, would they be able to under NASA's rules, or are these NASA rules requiring everyone to not talk about it? Thanks.
I have no idea.
I'm actually not sure of the answer to that, so you'll have to ask someone else.
Yes.
Joey, we can follow up with you on that question, but as a reminder for this specific crew, we won't be disclosing any further details, and the crew is not planning to identify themselves for this situation. All right, I think that is the final question we have for today. So we will go ahead and conclude today's news conference. Thank you for joining us, and welcome home, Crew 11.
too, so I don't know. I can't check. Okay. Sorry, pal. No, you're not. ready for his big dinner. Check. The shack, 10 for 2. Me and the chef's. You in the shack? No way. About that time.